I was standing in my garage organizing toolboxes when I heard the unmistakable sound of someone grunting and struggling just beyond my wooden fence. Living in Riverside, California, for the past 3 years had taught me that strange sounds in a quiet suburban neighborhood usually meant trouble, but nothing could have prepared me for what I was about to witness. I walked toward the side gate, and there she was. A middle-aged woman in a lime green polo shirt with our HOA logo emblazoned on the chest, halfway over my 6-foot privacy fence, digital camera dangling from her neck as she struggled to maintain her balance on what appeared to be a small stepladder on the other side. My name is Marcus Coleman, and I had just watched the HOA president, Patricia Henderson, literally climb my fence like some kind of deranged spy on a mission. She had not seen me yet, too focused on positioning her camera to take photos of my backyard. I stood there for a moment, genuinely stunned by the audacity. The woman was actually trespassing on my property to document what she probably considered violations of the homeowner association rules. "Can I help you with something?" I called out, my voice cutting through the quiet Saturday morning. Patricia nearly fell off the fence. She clutched at the top rail, her camera swinging wildly on its strap. When she finally steadied herself and looked down at me, her face flushed red, but not with embarrassment. No, that was pure indignation painted across her features. "I am conducting an inspection," she announced, as if that explained everything. "As HOA president, I have the authority to ensure all properties maintain our community standards." I crossed my arms and stared up at her. "You're on my property without permission. That's called trespassing." "I most certainly am not on your property," she argued, though she was quite literally straddling my fence. "I'm documenting violations from the easement." "The easement is on the ground, not 6 feet in the air hanging over my fence," I said. "And you're definitely about to put your feet on my property, which makes this trespassing. Get down and leave. Now." Patricia's expression hardened. She was in her late 40s with short blonde hair cut in that signature, "Let me speak to your manager" style. She wore khaki shorts with her HOA polo and sensible white sneakers that were now precariously balanced on the top of my fence. "I will not," she said firmly. "I have photographic evidence that you are in violation of at least 3 HOA regulations. Your grass exceeds the permitted height by approximately 1 inch, you have gardening equipment visible from neighboring properties, and your house number is not the approved font." I could not believe what I was hearing. "My grass is fine." "The gardening equipment is in my backyard behind a privacy fence, which you would not be able to see unless you were illegally climbing said fence. And the house number has been the same since I moved in 3 years ago. Nobody has ever said anything about it." "The regulations changed 6 months ago," Patricia said. "All homeowners received notice." "I received no such notice," I replied. "Now get off my fence before I call the sheriff." Her eyes narrowed. "You would not dare. Try me." We stared at each other for a long moment. Then Patricia did something that shocked me even more than her initial fence climbing adventure. She swung her other leg over and dropped down into my yard, landing with a thud on my grass. She immediately started snapping photos of everything: my gardening shed, my patio furniture, my grill, even the flower beds my late mother had helped me plant 2 years ago before she passed away. "This is your final warning," I said, pulling out my phone. "Leave my property immediately." "I am performing my duties as HOA president," she insisted, clicking away with her camera. "You signed the CC and Articus when you purchased this home. That gives me the right to inspect for violations." "It absolutely does not give you the right to trespass," I said, already dialing 911. Patricia seemed to think I was bluffing right up until the moment the dispatcher answered, and I calmly explained that someone had climbed my fence and was refusing to leave my property. Her face went pale and she rushed toward the gate. I stepped in front of it. "No, no," I said. "You wanted to be on my property so badly, you can stay right here until the sheriff's deputies arrive." "You cannot hold me here," she sputtered. "That is false imprisonment." "I'm not holding you anywhere," I said reasonably, stepping aside from the gate. "You're free to leave the same way you came in, over the fence." Patricia looked at the fence, then at me, then back at the fence. The stepladder was on the other side. There was no way she was getting over it from this direction without help. She had effectively trapped herself. The dispatcher told me officers were en route and to stay on the line if I felt threatened. I assured her I was fine, just annoyed. Patricia stood in the middle of my yard, clutching her camera like it was a shield, looking for all the world like she could not comprehend how her morning had gone so wrong. "This is harassment," she said. "I will have you brought before the HOA board for this behavior." "You climbed my fence," I said slowly, as if explaining something to a child. "You trespassed on my property. You refused to leave when asked. What part of that sounds like I'm the one harassing you?" She opened her mouth to respond, but the sound of a car pulling up in front of my house interrupted her. I walked through the side gate to the front yard, gesturing for Patricia to follow. She did, reluctantly, probably realizing that staying in my backyard when the police arrived would not look good for her. 2 deputies from the Riverside County Sheriff's Department were getting out of their patrol car. I recognized one of them, Deputy Williams, from a community meeting I had attended last year. He was a tall black man in his mid-30s with a professional demeanor. His partner was a younger Hispanic woman whose nameplate read Deputy Sanchez. "Mr. Coleman." Deputy Williams said, consulting his notes. "You called about a trespasser?" "Yes, sir," I said, then gestured to Patricia. "This is Patricia Henderson. She's the president of our HOA. I caught her climbing over my fence to take photos of my backyard. When I asked her to leave, she refused and actually jumped down into my yard. She only came out when she realized I was serious about calling you." Deputy Williams turned to Patricia. "Madam, is this accurate?" Patricia drew herself up to her full height, which was maybe 5'4". "I am conducting official HOA business. The CC and Articus give me the authority to inspect properties for violations." "Do they give you the authority to enter private property without permission?" Deputy Sanchez asked. "I have the right to document violations," Patricia insisted. "That does not answer my question," Deputy Sanchez said. "Did you enter Mr. Coleman's property without his permission?" Patricia's jaw tightened. "I was documenting visible violations from the easement." "She climbed my fence," I said. "I have security cameras. I can show you the footage." That was a bit of a bluff. I had been meaning to install security cameras for months, but had not gotten around to it yet. However, Patricia did not know that, and the color drained from her face. "That won't be necessary right now," Deputy Williams said, though he gave me a look that suggested he would want to see that footage later. "Madam, did you or did you not climb over Mr. Coleman's fence?" Patricia hesitated, then seemed to realize that lying to a sheriff's deputy was probably not her best move. "I may have used a ladder to get a better vantage point." "And did you enter his backyard?" Deputy Sanchez pressed. "Briefly," Patricia admitted. "But only to properly document the violations. As HOA president, it is my responsibility to follow the law," Deputy Williams interrupted, "which includes not trespassing on private property. Your HOA authority does not override property rights. But the CC and Articus," Patricia started, "are a civil matter," Deputy Williams said firmly. "Trespassing is a criminal matter. Mr. Coleman, do you wish to press charges?" I looked at Patricia. She was staring at me with an expression that mingled outrage, disbelief, and what might have been the first hint of actual concern. Part of me wanted to just let it go, to be the bigger person and chalk it up to an overzealous HOA president who had gotten carried away. But then I remembered the camera full of photos, the threats about violations, the complete disregard for my privacy and property rights. "Yes," I said. "I want to press charges." Patricia's mouth fell open. "You cannot be serious." "Dead serious," I replied. "You trespassed on my property, refused to leave when asked, and threatened me with HOA violations for daring to object. That is not acceptable behavior, HOA president or not." Deputy Sanchez pulled out her citation book, while Deputy Williams explained to Patricia that she was being cited for trespassing. It was a misdemeanor, he explained, and she would need to appear in court or pay the fine. Patricia's face cycled through about 15 different emotions as this was happening, finally settling on a sort of cold fury. "You will regret this," she told me. "I promise you that. Madam, I would not recommend making threats in front of law enforcement," Deputy Williams said mildly. Patricia clamped her mouth shut, snatched the citation from Deputy Sanchez's hand, and stalked off toward her white Lexus SUV parked 3 houses down. We all watched her peel away from the curb with a screech of tires. "That went well," I muttered. Deputy Williams chuckled. "HOA disputes are some of the most heated calls we get. People get crazy about property issues. You said you have security footage." "I was planning to install cameras this weekend," I admitted. "But after this, it just moved to the top of my priority list." "Good idea," Deputy Sanchez said. "And for what it's worth, you were within your rights. Even HOA board members cannot just enter your property whenever they want. If they suspect violations, they need to follow proper procedures." "Which are?" I asked. "Usually written notice of the alleged violation, opportunity to cure it, then potentially a hearing," Deputy Williams explained. "But I'm not an HOA expert. You might want to consult with an attorney if this escalates." Those words proved prophetic. After the deputies left, I went inside and did something I probably should have done when I first moved into this neighborhood. I actually read the complete CC and Artiques, all 73 pages of them. It took me 3 hours and 2 pots of coffee, but I made it through. What I discovered was enlightening, and more than a little disturbing. The regulations were extensive, covering everything from approved paint colors to the exact species of trees allowed in front yards. There were rules about holiday decorations, garage door positions, mailbox styles, and even what time of day you could water your lawn. But nowhere, absolutely nowhere, did it give the HOA board or president the authority to enter private property without permission. There was a provision for exterior inspections, but it specifically stated these were to be conducted from public streets, sidewalks, or common areas. Patricia had been completely in the wrong, which I had known, but seeing it in writing made me feel better about pressing charges. What worried me was what she might do in retaliation. Someone who thought it was acceptable to climb a fence to photograph violations was probably not going to take being cited for trespassing lying down. I did not have to wait long to find out. Monday morning, I received a certified letter from the HOA. Inside was a notice of violation for 6 different infractions: grass height, unapproved house numbers, visible storage equipment, non-conforming fence color, unauthorized landscaping modifications, and improper outdoor furniture placement. Each violation came with a fine of $250. I was being charged $1,500 total, with a demand for payment within 30 days or face additional fines and potential legal action. I sat at my kitchen table and laughed, actually laughed, at the absurdity of it. Patricia was retaliating exactly as I had expected, but she had made a crucial mistake. Every single one of these violations was either fabricated or related to things she could only have seen by trespassing on my property. The fence color. My fence was the exact shade of brown specified in the approved colors list. I had the paint receipt to prove it. The outdoor furniture. Behind my privacy fence, not visible from any public area. The landscaping modifications. My mother's flower beds, which had been there for 2 years without complaint. I called the law office of Sarah Martinez, an attorney I had found through a quick internet search who specialized in HOA disputes. Her receptionist scheduled me for a consultation that afternoon. I brought all my documentation. The violation notice, my copy of the CC and Articus, photos of my property, the paint receipt, and a written timeline of Saturday's events including the deputy's citation number. Sarah Martinez was a sharp-eyed woman in her early 50s with an air of competence that immediately put me at ease. She reviewed my documents while I explained the situation. When I finished, she leaned back in her chair and smiled. "This is one of the more blatant cases of HOA retaliation I have seen in a while," she said. "And I see a lot of HOA cases. The fact that she was cited for trespassing while attempting to document these violations is going to be very helpful for your case." "So what do?" I asked. "First, we respond to these violation notices with a formal dispute. We will point out that several of these alleged violations involve areas of your property that are not visible from public access points, which raises questions about how they were observed. We will also note that the CC and Articus do not authorize property entry for inspections. Second, we file a complaint with the HOA board about Patricia's conduct. Even if she's the president, the full board needs to be made aware of her actions." "Will that actually do anything?" I asked skeptically. "It creates a paper trail," Sarah explained. "If this goes to court, and it might, we need to show that you followed proper procedures and attempted to resolve things through appropriate channels. Third, and this is optional, we can send Patricia a personal cease and desist letter regarding harassment and threatened property rights violations." "How much is all this going to cost me?" I asked. It was the practical question, and I needed to know if fighting this was even financially feasible. Sarah quoted me her rates, which were not cheap, but not outrageous either. She also offered to work on a partial contingency basis if we ended up suing the HOA for harassment and damages. "Let me think about it," I said, though I was already pretty sure I was going to hire her. Patricia had crossed a line, and bullies only stopped when someone stood up to them. I left Sarah's office and drove back home, only to find Patricia's Lexus parked in front of my house again. She was standing on the sidewalk with another woman I did not recognize, both of them staring at my house and consulting a clipboard. When I pulled into my driveway, they did not leave. Instead, Patricia marched up to me as I got out of my truck. "We need to discuss these violations," she announced. "No, we do not," I said evenly. "Any communication regarding HOA matters needs to go through my attorney." "Your attorney?" Patricia's voice rose. "Are you seriously lawyering up over some basic community standards? You trespassed on my property and are now retaliating with fabricated violations," I said. "Yes, I have an attorney. Her name is Sarah Martinez. Direct all further communication to her office." The other woman, who Patricia introduced as Linda Ferguson, the HOA vice president, looked uncomfortable. "Marcus, I am sure we can resolve this like reasonable adults." I tried being reasonable on Saturday, I said. I asked Patricia to leave my property. She refused. I am done being reasonable. Patricia's face was turning an alarming shade of red. Those violations are legitimate. If you refuse to address them, the fines will increase exponentially. We can put a lien on your house. Try it, I said. My attorney would love that. Now please leave. You are on my property. Technically, they were on the sidewalk, which was public property, but I wanted to make my point clear. The sidewalk is public access, Patricia said triumphantly. Then you would not mind if I stood here and took photos of you, would you? I pulled out my phone and started filming. Just documenting things for my records. Patricia grabbed Linda's arm and practically dragged her back to the Lexus. I kept filming until they drove away, then immediately sent the video to myself via email as backup. I was learning to document everything. That evening, I did install the security cameras I had been putting off. I bought a comprehensive system from Home Depot. Cameras covering my front door, driveway, both sides of my house and my backyard. It took me until nearly midnight to get everything set up and running, but when I finally went to bed, I felt better knowing that any future trespassing attempts would be captured in high definition. I was glad I had installed them too, because at 2 in the morning my phone buzzed with a motion alert. I groggily opened the security app and felt instantly awake when I saw what was on the screen. Someone was walking through my backyard with a flashlight. I could not make out who it was from the camera angle, but they were definitely not supposed to be there. I called 911 for the second time in 3 days, then pulled on jeans and a shirt and grabbed the baseball bat I kept in my closet. I was not planning to confront whoever was out there, but I wanted to be prepared. I watched through my back window as the figure moved around my yard, seemingly taking measurements of something. The flashlight beam swept across my fence, my shed, my patio. Within 6 minutes, I heard sirens. The figure in my backyard heard them too and made a run for the fence. I watched on my phone's camera feed as they struggled to climb over, eventually making it over the top just as the red and blue lights illuminated my front yard. I went to my front door and found Deputy Sanchez along with a male deputy I did not recognize. Someone was in my backyard, I said immediately. I got an alert from my security cameras. They went over the back fence maybe 30 seconds ago. Stay here, Deputy Sanchez instructed, and both deputies took off around the side of my house with their flashlights. I stood in my doorway, heart pounding, until they returned about 5 minutes later. Whoever it was is gone, Deputy Sanchez reported. But we found this on the ground near your fence. She held up an evidence bag containing a tape measure with a logo on it. The logo for Clearview HOA Management, the company that managed our neighborhood association. You are kidding me, I breathed. You recognize this? The other deputy asked. That is my HOA Management company's logo, I said. The same HOA whose president I had cited for trespassing on Saturday. The deputies exchanged looks. We will need a copy of your security footage, Deputy Sanchez said. I pulled up the app on my phone and showed them the footage. The quality was not perfect in the dark, but you could clearly see someone in my yard who should not have been there. The deputies took down all the information and said they would follow up with the HOA Management company to see if they could identify the person on the video. I barely slept the rest of the night. When morning came, I was exhausted and angry. This had gone way beyond a simple HOA dispute. People were now trespassing on my property in the middle of the night. I called Sarah Martinez's office as soon as they opened and left a detailed message about what had happened. She called me back within 20 minutes. We are filing an emergency restraining order, she said immediately. This has escalated beyond reasonable HOA activity. Someone trespassing on your property at 2 in the morning is a serious safety concern. Can we do that? Get a restraining order against an HOA? I asked. We can get one against Patricia Henderson personally, and potentially other board members if we can prove they are coordinating this harassment, Sarah explained. I am also going to contact the HOA's management company and their insurance carrier. Trust me, once their insurance company hears about this, they are going to put a stop to it fast. Insurance companies hate this kind of liability. Things moved quickly after that. By Wednesday afternoon, we had filed for a temporary restraining order against Patricia Henderson, barring her from coming within 100 feet of my property or contacting me directly. We also sent formal notifications to the HOA board, the management company, and their insurance carrier detailing the incidents and informing them that any further trespassing or harassment would result in additional legal action. The response was swift and dramatic. Thursday morning, I received a call from a man named Robert Chen, who identified himself as the regional director for Clearview HOA management. He sounded both apologetic and deeply concerned. Mr. Coleman, I want to assure you that Clearview does not condone or authorize any form of trespassing or harassment, he said. We are conducting an internal investigation into these incidents. I have reviewed the security footage you provided to law enforcement, and I can confirm that the person in your yard appears to have been wearing a Clearview uniform shirt. So, one of your employees was trespassing on my property in the middle of the night, I said flatly. We are working to identify which employee it was, Robert said. However, I want to be clear that at no time did any Clearview manager authorize such activity. If one of our employees was on your property without permission, they were acting outside their job duties and will face disciplinary action up to and including termination. I appreciate that, I said, but it does not change the fact that this happened. Someone associated with the HOA has now trespassed on my property twice in less than a week. I do not feel safe in my own home. I understand completely, Robert said. What can we do to make this right? We talked for another 30 minutes. It was more than I had expected, but I could tell Robert was genuinely worried about the liability. Sarah had been right. Insurance companies and management companies did not want any part of this kind of lawsuit. The temporary restraining order hearing was scheduled for the following Monday. Sarah assured me it was mostly a formality given the documented trespassing incidents and the police reports. What I did not expect was for Patricia to show up at the hearing with her own attorney, a stern-looking man in an expensive suit, who immediately began arguing that the restraining order was unnecessary and vindictive. My client was merely performing her elected duties as HOA president, he argued to the judge. Any alleged trespassing was unintentional and done in good faith to maintain community standards. Judge Rachel Morrison, a no-nonsense woman in her 60s, peered over her reading glasses at Patricia's attorney. Counselor, are you seriously arguing that climbing over a 6-foot fence into someone's backyard is an unintentional act done in good faith? My client disputes that characterization of events, he said smoothly. Your client was cited by the Riverside County Sheriff's Department for trespassing, Judge Morrison said dryly. That is a matter of public record. Do you have any evidence that the citation was issued in error? Patricia's attorney hesitated. Not at this time, Your Honor. Then I am inclined to grant the restraining order, Judge Morrison said. She turned to Sarah. Counselor Martinez, what are you asking for? A minimum distance of 100 feet between Miss Henderson and my client or his property, Your Honor. Also prohibition of any direct or indirect contact, including through third parties. Granted, Judge Morrison said. Miss Henderson, you are to stay at least 100 feet away from Mr. Coleman and his property at all times. You are not to contact him directly, by phone, email, text, through social media, or through any third party acting on your behalf. This order will remain in effect for 6 months, at which time we can review it if necessary. Violation of this order will result in criminal contempt charges. Do you understand? Patricia stood up, her face tight with anger. Your Honor, I live in the same neighborhood. How am I supposed to stay 100 feet away at all times? I suggest you plan your routes carefully, Judge Morrison said. This court is adjourned. As we left the courthouse, Sarah was smiling. That went as well as we could have hoped. What happens now with the HOA stuff? I asked. Is this over? Not quite, Sarah said. We still need to resolve the civil issues. The withdrawn violations are a good start, but we should probably attend the next HOA board meeting and make sure everyone understands what is and is not acceptable going forward. The next board meeting was scheduled for 2 weeks later. In the meantime, I tried to get back to some semblance of normal life. I was a freelance graphic designer, which meant I worked from home most days. The constant stress of the HOA situation had made it hard to focus on client work, and I was behind on several projects. I spent the next week catching up, barely leaving my house except for grocery runs and a visit to my local gym. My neighbors started approaching me, tentatively at first. Most of them had received the letter from Clearview about the investigation into Patricia's conduct. Public opinion was divided. Some people thought I was making a mountain out of a molehill and should have just paid the fines to keep the peace. Others were quietly supportive, admitting that they had also had uncomfortable encounters with Patricia, but had been too intimidated to push back. One neighbor, an older gentleman named Frank Morrison who lived 2 houses down, stopped by one evening with a 6-pack of beer and a story. Patricia tried to fine me $3,000 last year, he told me as we sat on my front porch. Said my roof shingles were not the approved color. I had just replaced the whole roof the year before with shingles from the approved vendor list. I showed her my receipts, showed her where those exact shingles were listed as approved. She insisted they looked different in person than in the photos. What did you do? I asked. I paid it, Frank admitted, looking embarrassed. My wife has health issues. We did not need the stress of fighting the HOA, but I have always regretted it. What you are doing, standing up to her, it is what someone should have done a long time ago. I wish it had not come to this, I said honestly. I just want to live in my house in peace. Well, you are not alone, Frank said. There are a lot of us who are tired of Patricia's power trips. If you need people to speak at the board meeting, let me know, I'll be there. True to his word, Frank showed up at the HOA board meeting, along with about 30 other homeowners. It was the largest turnout the association had seen in years. The meeting was held in the community clubhouse, a bland beige room with folding chairs and fluorescent lighting. Linda Ferguson, the vice president, was running the meeting in Patricia's absence. Linda looked nervous as she called the meeting to order. Before we begin with regular business, I want to address the situation with our president, Patricia Henderson. As many of you know, there has been an incident involving allegations of trespassing. Patricia is currently on administrative leave while this matter is investigated. In the meantime, I will be assuming her duties. What really happened? Someone called out from the back. Linda hesitated. That is part of an ongoing investigation, and I am not at liberty to discuss details. I can discuss details, I said, standing up. Since I was the one Patricia trespassed against. The room went silent. All eyes turned to me. I had not planned to speak. had actually hoped to just observe the meeting, but something about Linda's evasiveness made me angry. These people deserved to know what their HOA president had been doing in their name. I laid out the whole story, from catching Patricia climbing my fence to the middle of the night trespassing incident to the restraining order. I kept my tone factual and unemotional, just presenting the facts. When I finished, the room erupted in conversation. Is this true? Someone demanded of Linda. The board is investigating, Linda said weakly. The sheriff's department investigated, I said. Patricia was cited for trespassing. That is public record. Someone wearing a Clearview uniform was on my property at 2 in the morning. That is on my security footage. These are not allegations. These are facts. Frank stood up. I think we need to call for a vote of no confidence in Patricia Henderson. She has abused her position and exposed this HOA to serious liability. We cannot just remove an elected president, Linda protested. Actually, we can, said a woman I did not know from the other side of the room. Article 7, Section 3 of the bylaws. Any board member can be removed by a 2/3 vote of the homeowners present at a properly noticed meeting. This is a properly noticed meeting and we have a quorum. Linda looked panicked. This is not on the agenda. Then we will add it to the agenda, the woman said. I move that we add a vote of no confidence in Patricia Henderson to tonight's agenda. Second, Frank called out. The motion passed nearly unanimously. Only 2 people voted against adding it to the agenda, and I suspected they were Patricia's friends. The actual vote of no confidence was scheduled for after the regular business was completed, giving everyone a chance to discuss it. The regular business was rushed through in record time. Nobody cared about landscaping bids or pool maintenance contracts when there was drama to be had. When Linda finally, reluctantly, opened the floor for discussion about Patricia's removal, the floodgates opened. Person after person stood up with stories about Patricia's overzealous enforcement of rules, her confrontational attitude, and her refusal to listen to reasonable explanations. One couple talked about being fined for having their garbage cans visible from the street on a day that was not trash day, even though the trash company had changed their pickup schedule without notice. Another homeowner described being threatened with legal action for planting roses that were apparently half a shade too pink compared to the approved color palette. It became clear that I was not the only person Patricia had targeted. I was just the first one to fight back publicly. When the discussion finally wound down and Linda called for the vote, the result was overwhelming. Patricia Henderson was removed as HOA president by a vote of 28-2. What happens now? Someone asked. The vice president assumes presidential duties until the next election, Linda said. She looked shell-shocked. That would be me. Are you going to continue Patricia's policies? Frank asked pointedly. No, Linda said quickly. Absolutely not. I never agreed with her aggressive enforcement tactics. I am going to propose at our next board meeting that we completely overhaul our violation procedure to include better notice, clearer standards, and an appeals process. The meeting broke up shortly after that. Several people came up to me to thank me for speaking out. A few apologized for not supporting me sooner. I felt a strange mixture of vindication and exhaustion. This was not how I had wanted to spend my spring, embroiled in HOA politics and restraining orders. But at least something positive had come from it. Sarah called me the next morning after I emailed her an update about the meeting. This is excellent, she said. With Patricia removed from the board, the HOA's liability is significantly reduced. They can argue that her actions were not authorized and that they took swift corrective action once they became aware of the problem. So where does that leave my case? I asked. We should probably settle, Sarah said. With Patricia off the board and new leadership promising reforms, continuing to pursue legal action against the HOA itself would be expensive and might make you look vindictive. But we can absolutely pursue a personal case against Patricia for harassment and emotional distress. How much are we talking about? I asked. For harassment and emotional distress with the evidence we have, probably somewhere in the $10,000 to $20,000 range if we go to court. Maybe more if we can prove damages. Have you had any income loss due to this situation? I thought about the client projects I had been late on. Maybe. I have been behind on work because of all this stress. Document everything, Sarah advised. Every hour spent dealing with HOA issues, every client deadline you missed, every dollar spent on security cameras or other protective measures. It all adds up. I spent the next week putting together a comprehensive timeline and expense report. The security cameras had cost me $800. I had missed deadlines on 2 client projects, which had cost me roughly $3,000 in income when those clients took their business elsewhere. I had spent over 40 hours dealing with HOA correspondence, meetings, and legal consultations. At my standard hourly rate, that was another $6,000 in lost income. The attorney fees so far were approaching $5,000. By the time I tallied everything up, Patricia's vendetta had cost me nearly $15,000 in direct expenses and lost income, not counting the emotional stress and anxiety. Sarah reviewed my documentation and nodded approvingly. "This is good," she said. "Very thorough. I am going to send a demand letter to Patricia's personal attorney. We will ask for $25,000 to settle all claims, which gives us room to negotiate down if needed." "You think she will pay?" I asked. "Her homeowner's insurance might cover it," Sarah said. "That is what I am hoping. If it does, they will probably settle quickly to avoid the cost of litigation. If it does not, then we will see how stubborn Patricia wants to be." The answer, it turned out, was very stubborn. Patricia's attorney responded to our demand letter by essentially telling us to pound sand. His client had done nothing wrong, he claimed. She was merely trying to enforce community standards, and if I had just complied with the regulations, none of this would have happened. "Guess we are going to court," Sarah said when she called to tell me about the response. Filing the lawsuit was surprisingly straightforward. Sarah handled all the paperwork, and I just had to sign where she told me to sign. We sued Patricia personally for harassment, trespass, emotional distress, and retaliation. We asked for $25,000 in compensatory damages plus attorney fees and court costs. Patricia was served with the lawsuit papers at her home on a Tuesday morning. I know this because she violated the restraining order by calling me directly about an hour after being served. My phone rang with an unfamiliar number, and I made the mistake of answering. "You are ruining my life." Patricia shrieked into the phone before I could even say hello. "I lost my position as HOA president, and now you are suing me. Do you have any idea what this is doing to my reputation?" "This call is a violation of the restraining order," I said calmly. "Do not contact me again." I hung up and immediately called the non-emergency sheriff's line to report the violation. I also texted Sarah to let her know what had happened. She told me to document everything, which I did. The deputy who responded to my call was sympathetic, but not surprised. "HOA disputes bring out the worst in people," he said as he took my statement. "We will follow up with Miss Henderson about the restraining order violation. If she contacts you again, call us immediately." Patricia's violation of the restraining order ended up working in our favor. Her attorney tried to claim that his client was under extreme stress and had acted impulsively. But Judge Morrison was not having it. Your client was explicitly warned that violation of the restraining order would result in contempt charges, the judge said at the hearing a week later. She has now violated that order. Miss Henderson, you are fined $500 for contempt of court. If you violate this order again, you will spend a night in jail. Do I make myself clear? Patricia's face was pale as she nodded. Her attorney looked frustrated. I had the distinct impression that Patricia was not listening to his advice, which was probably making his job much harder. As we waited for the civil trial date, more information came to light about Patricia's activities as HOA president. Linda, in her new role, conducted a review of HOA enforcement actions over the past 2 years. What she found was disturbing. Patricia had issued over 200 violation notices during her tenure, far more than any previous HOA president. The total fines assessed exceeded $100,000. And in at least 30 cases, homeowners had simply paid the fines rather than fight them, even when the violations were questionable or based on rules that did not exist in the CC and Articles. Linda brought this information to the HOA board, and they voted unanimously to refund any fines paid for violations that could not be substantiated with reference to the actual CC and Articles. This resulted in over $20,000 being returned to homeowners. The HOA also hired an attorney to review and update the CC and Articles to make them clearer and more reasonable. All of this made Patricia look worse and worse. She had essentially been running a shakedown operation, fining people for made-up violations, and counting on them being too intimidated or uninformed to fight back. When our trial date finally arrived 6 months after the original fence climbing incident, Patricia's attorney tried to get a continuance. Judge Morrison denied it. The trial lasted 2 days. Sarah presented our evidence methodically. The sheriff's reports documenting the trespassing incidents, the security footage showing someone in my yard at 2 in the morning, the pattern of retaliatory violations issued after I refused to just pay the fines, the restraining order and Patricia's violation of it, and my documentation of expenses and lost income. Patricia's attorney tried to argue that his client had been acting in her capacity as HOA president and therefore deserved some protection. Sarah demolished that argument by pointing out that the HOA itself had removed Patricia from her position, and that the management company had explicitly stated her actions were not authorized. The most damaging testimony came from Frank and 3 other neighbors who testified about their own experiences with Patricia's aggressive enforcement tactics. It established a pattern of behavior that made Patricia's actions against me look less like an isolated incident and more like part of an ongoing pattern of harassment. Patricia herself was not a good witness. She was defensive and argumentative, insisting that she had done nothing wrong and that everyone was overreacting. At one point, she actually told the judge that homeowners who did not want to follow the rules should not live in an HOA community. Judge Morrison's expression made it clear that this was not winning Patricia any sympathy. The jury deliberated for less than 3 hours. They found in my favor on all counts and awarded me $32,000 in compensatory damages, plus attorney fees and court costs. With Sarah's fees and expenses, the total judgment came to just over $47,000. Patricia looked like she had been slapped as the verdict was read. Her attorney immediately began talking about appeals, but Sarah told me later that appeals were expensive and rarely successful on cases with this kind of evidence. She predicted Patricia would ultimately pay rather than throw good money after bad. She was right. 6 weeks after the verdict, Patricia's attorney contacted Sarah with an offer to settle the judgment for the full amount without appeal. Patricia's homeowner's insurance had agreed to pay $30,000, which was the limit of her liability coverage for personal injury claims. Patricia herself would have to come up with the remaining $17,000. I accepted the settlement. I was not trying to bankrupt Patricia, just hold her accountable for her actions. The money helped recoup my expenses and compensated me for the months of stress and hassle. More importantly, it sent a message to the entire community about what happened when HOA board members abused their authority. The fallout continued even after the settlement. Clearview HOA management conducted its internal investigation and determined that the employee who had trespassed on my property at 2 in the morning had been acting on Patricia's direct instructions. She had told him there were violations that needed to be documented and that I was being uncooperative. The employee, who had only been with the company for 6 months, was given a written reprimand and additional training on property rights and legal boundaries. Patricia's access to Clearview employees was permanently revoked. The story spread throughout Riverside. Local news outlets picked it up, running stories about HOA overreach and abuse of power. I gave a couple of interviews, always stressing that I was not against HOAs in general, but against board members who thought their position gave them unlimited authority. The story resonated with people who had their own HOA horror stories. The publicity was not entirely welcome. I had not wanted to become the poster child for HOA reform, but it did lead to one positive outcome. A local state assemblyman contacted me about testifying in favor of proposed legislation to increase accountability and transparency in HOAs. The bill would require better notice for violations, mandatory appeals processes, and penalties for board members who abused their authority. I testified at a committee hearing in Sacramento, telling my story to a room full of legislators and lobbyists. It was nerve-wracking but also empowering. Several other homeowners testified as well, each with their own tales of HOA overreach. The bill ended up passing the committee and moving forward in the legislative process. Back home in Riverside, life slowly returned to normal. The new HOA board under Linda's leadership was night and day different from Patricia's regime. Violations were issued only for serious issues that affected property values or safety. The violation process included clear notice, a reasonable time frame to cure issues, and an opportunity to appeal before fines were assessed. The board even started a quarterly newsletter to keep homeowners informed about decisions and upcoming projects. Patricia herself largely disappeared from community life. I would occasionally see her driving through the neighborhood, always taking care to stay on the opposite side of the street from my house. We never spoke. Her house went up for sale about 8 months after the trial, and she moved to a different neighborhood in a different part of Riverside. I heard through the grapevine that she was telling people she had left because the community had become too hostile. No one felt particularly sympathetic. My relationship with my other neighbors improved significantly. Frank became a good friend. We would have beers on my front porch and talk about sports, politics, and occasionally HOA gossip. Other neighbors would stop by to chat when they saw me outside. I felt more connected to my community than I had in the 3 years before the whole Patricia situation started. The security cameras I had installed stayed up. I had gotten used to the peace of mind they provided. They captured mostly boring footage: delivery drivers, the occasional stray cat, neighbors walking their dogs. Exactly what I wanted to see. No more middle-of-the-night trespassers. No more HOA presidents climbing my fence. About a year after the fence incident, I was working in my home office when my doorbell rang. I checked the security camera feed on my computer and saw an unfamiliar woman standing on my porch holding a clipboard. My first instinct was to ignore it, assuming it was either a solicitor or someone else from the HOA. But something made me answer the door. The woman was in her early 30s, professionally dressed, with a friendly smile. "Hi, are you Marcus Coleman?" "Yes," I said cautiously. "My name is Jennifer Park. I am a reporter with the Sacramento Bee. I am working on a series about HOA governance in California, and your name keeps coming up. Would you be willing to talk to me about your experience?" I almost said no. I had done my interviews after the trial, told my story, moved on. But Jennifer explained that she was not just writing about my case specifically. She was investigating a pattern of HOA abuse across California and was looking for examples to include in a comprehensive feature article. "This is bigger than just your situation," she said. "I have found dozens of cases similar to yours. HOA board members abusing their authority, homeowners being fined for made-up violations, management companies that enable bad behavior because it generates revenue. But most people are too scared to speak publicly. Your case is unusual because you fought back and won. That makes you an important voice in this conversation." I invited her in, and we talked for over 2 hours. I told her everything, from the fence climbing to the trial to the legislative testimony. Jennifer took detailed notes and asked thoughtful questions. When she finally left, she promised to send me a copy of the article before it was published. The article came out 3 months later as a 5-part series. It was extensively researched and devastating in its conclusions. Jennifer had found that HOAs in California issued over $50 million in fines annually, much of it for minor or questionable violations. She documented cases of board members enriching themselves through contracts with vendors they had financial interests in. She exposed management companies that coached board members on how to maximize fine revenue because the management companies took a percentage of collected fines. My story was featured prominently in Part 3, which focused on enforcement overreach. Jennifer had also tracked down Patricia and interviewed her. Patricia's quotes were predictably defensive, but Jennifer's reporting made it clear that Patricia's behavior was part of a much larger systemic problem. The series won awards and prompted several legislative initiatives. The bill I had testified for eventually passed and was signed into law, providing new protections for homeowners and accountability measures for HOA boards. It was not perfect, but it was progress. As for me, I continued living in my house in Riverside, working on my graphic design projects, and occasionally giving interviews or testimony about HOA reform. I had not asked to become an advocate for homeowners' rights, but I had learned that sometimes standing up for yourself means standing up for others too. The whole experience taught me several important lessons. First, document everything. If I had not had that documentation, proving my case would have been much harder. Second, do not be afraid to stand up to bullies, even when they have official titles and authority. Third, you are probably not alone. If someone is abusing their power against you, they are likely doing it to others too. And fourth, never underestimate the power of a well-placed security camera. If I had not installed those cameras when I did, I might never have caught the midnight trespasser. That footage was crucial to my case and to exposing the pattern of harassment. My life settled into a comfortable routine. I took on new clients, including some work designing materials for HOA reform organizations, which felt appropriately ironic. I started dating someone I met at the gym, a teacher named Amanda Harper, who thought my HOA war stories were hilarious. We would joke about starting a support group for HOA survivors. Frank and I organized a neighborhood barbecue to celebrate the one-year anniversary of Patricia's departure. Nearly every house on our street showed up. We grilled burgers and hot dogs. The kids ran around the common area playground, and for a few hours, it felt like what a community was supposed to feel like. No one was worried about their grass being a quarter-inch too tall or their house numbers being the wrong font. We were just neighbors, enjoying each other's company. Linda came by the barbecue and pulled me aside at one point. "I wanted to thank you," she said. "I know things got pretty ugly for a while, but you forcing this issue, it made us all take a hard look at how this HOA was being run. We are so much better now." "You are the one doing the work," I said. "I just made some noise." "Sometimes noise is what is needed," Linda replied. She clinked her beer bottle against mine. "To making noise." "To making noise," I agreed. The restraining order against Patricia expired after 6 months as scheduled. There was a hearing where we could have extended it, but Sarah and I agreed it was not necessary. Patricia was gone from the neighborhood and had shown no signs of continuing harassment. Judge Morrison let the order expire but warned Patricia that any future contact with me would be taken very seriously given the history. I never saw Patricia again after that hearing. According to the neighborhood grapevine, she had moved to a house in a different HOA and had been expressly forbidden by that HOA's board from serving in any leadership capacity after they learned about her history. I hoped she had learned something from the experience, but I was not holding my breath. The lawsuit settlement money went toward several things. I paid off the rest of my attorney fees, obviously. I put a chunk into savings. I donated $5,000 to a nonprofit that provided legal assistance to homeowners dealing with HOA disputes. And I used the rest to take Amanda on a proper vacation to Hawaii, where we spent a week on the beach in Maui, not thinking about HOAs, violations, or property rights. Sitting on that beach, watching the sunset over the Pacific Ocean, I reflected on everything that had happened. A year ago, I had been standing in my garage, hearing that strange sound and going to investigate. That one moment had led to months of stress, conflict, and ultimately legal action. But it had also led to real change, not just for me but for my entire community and potentially for homeowners across California. Would I have done anything differently if I could go back? Maybe I would have installed the security cameras sooner. But otherwise, no. Patricia had been wrong to climb my fence, wrong to trespass, wrong to retaliate with fabricated violations. Standing up to her had been the right choice, even when it was difficult and expensive and stressful. When Amanda and I got back from Hawaii, I finally felt like the Patricia chapter of my life was truly closed. I had my settlement, my community had new leadership, and the legislative changes meant other homeowners would have better protections. I could focus on my work, my relationship, and just living my life without constantly looking over my shoulder. But the universe apparently had one more twist in store. About 6 months after the Hawaii trip, I got a call from Detective Mark Riley with the Riverside County Sheriff's Department. He asked if I could come in to answer some questions about Patricia Henderson. My stomach dropped. "What is this about?" "I would rather discuss it in person," Detective Riley said. "Are you available this afternoon?" I met with Detective Riley at the sheriff's station, feeling nervous despite having done nothing wrong. He was a tired-looking man in his 50s with graying hair, and the demeanor of someone who had seen too much of humanity's worst behavior. "Thank you for coming in," he said, gesturing for me to sit in a small interview room. "I am investigating a complaint filed by several homeowners in Patricia Henderson's new neighborhood, Apparently, she has been engaging in similar behavior to what you experienced. Trespassing, harassment, threatening violations. One of the homeowners mentioned your case when they were filing their complaint, which is how I got your name. She's doing it again, I asked, not entirely surprised but still disappointed. I had hoped Patricia would have learned something. Apparently. She is not on the HOA board in her new neighborhood, but that has not stopped her from acting like she is. She has been walking around taking photos of properties, leaving violation notices on doors, even allegedly entering people's yards without permission. Detective Riley pulled out a file. I wanted to ask you about your experiences with her, specifically about the nighttime trespassing incident with the Clearview employee. We talked for over an hour. I went through the whole story again, providing copies of documents and evidence I had kept. Detective Riley was particularly interested in the pattern of behavior and the fact that Patricia had directed an employee to trespass on my property. This helps establish a pattern, he said. The homeowners in her new neighborhood are considering criminal harassment charges. Your testimony about your experiences could be relevant. Whatever I can do to help, I said. I ended up testifying before a grand jury about my experiences with Patricia. The grand jury was investigating whether her pattern of behavior constituted criminal harassment and stalking under California law. My testimony, combined with that of the homeowners in her new neighborhood and documentary evidence, led to Patricia being indicted on multiple misdemeanor harassment charges. The criminal trial took place about 8 months later. I was called as a witness and spent half a day on the stand describing what Patricia had done to me and my property. The prosecutor used my case to establish that Patricia had engaged in this behavior before and that it was a deliberate pattern, not just misunderstandings or overzealous enforcement. Patricia's defense attorney tried to argue that his client was mentally ill and needed treatment, not punishment. The prosecutor countered that Patricia had demonstrated clear intent and planning in her actions, which argued against any kind of mental defect defense. She knew what she was doing was wrong. She had just convinced herself that her position justified it. The jury found Patricia guilty of 4 counts of misdemeanor harassment. The judge sentenced her to 1 year of probation, 200 hours of community service, mandatory counseling, and a permanent ban on serving in any HOA leadership position. It was not prison time, but it was justice. After that trial, I really was done with the Patricia saga. She was legally barred from contacting me, from serving on HOA boards, and was under court supervision. If she violated any of those conditions, she would face jail time. That was enough for me. Life moved on. Amanda and I got engaged. I landed a major client that provided steady work and good income. The neighborhood continued thriving under Linda's reasonable leadership. The legislative reform started making a real difference, with homeowners across California reporting better experiences with their HOAs. I still get occasional calls from reporters, attorneys, or advocacy groups asking about my experience. I am always happy to share my story if it helps someone else. But mostly, I am just happy to be a regular guy living in his house in Riverside, California, without anyone climbing his fence or photographing his backyard without permission. The whole experience, as stressful as it was, taught me the value of standing up for yourself and the importance of community. It also taught me that sometimes the people in positions of authority need to be reminded that their power has limits. Patricia had forgotten that. She thought being HOA president gave her the right to do whatever she wanted. The legal system, and ultimately the community, reminded her that was not how it worked. I occasionally drive past Patricia's old house. A nice family with young kids lives there now. They have a tire swing in the backyard and a well-maintained garden in the front. Their house numbers are probably the wrong font, and I would bet their grass is sometimes a little too tall. But nobody is climbing their fence to photograph it. Nobody is fining them for made-up violations. They are just living their lives in their house, exactly as it should be. And that, more than anything else, made everything I went through worthwhile. Because if Patricia had gotten away with what she did to me, she would have kept doing it to others. By standing up to her, by refusing to just pay the fines and move on, I helped create a community where people could live without fear of arbitrary enforcement and harassment. So yes, Patricia Henderson climbed my fence to photograph violations, and I called the sheriff for trespassing. And I would do it again in a heartbeat, because sometimes doing the right thing is more important than keeping the peace. Sometimes you have to make noise. Sometimes you have to stand up to bullies, even when they have titles and authority and official-looking letterhead. And sometimes, just sometimes, standing up for yourself means standing up for everyone,